Okay, ladies and gentlemen, it's 1:45, so the inquiry is in session again. Ms. Osman-Smith, may I invite you to start cross-examination?
Thank you very much, Madam. Yes, and good afternoon, Mr. Carpenter. If I just run through the documents that you will need, we have core document 4.7.1, Statement of Common Ground with the Council. We've got core document 1.78, which is the Drainage Strategy Plan. We've got core document 129, which is the Flood Risk Assessment and Outline Surface Water Drainage Strategy from May 2024. We've got the proofs, rebuttals and Pound Road appeal decision at core document 7.3. 7.3. You're ready. Okay, well, we're going to start with Pound Road because that popped up again in your evidence. And it's useful to go there, core document 7.3, to just understand the extent to which there are any differences between this site and that site. So do you have access to that appeal decision? Mr. Jones is jumping into action to come and assist. You have that. So if you can turn within that, please, to paragraph 54. And you will read there, it was uncontested at the inquiry that there are 32 identified wells, boreholes and springs in the vicinity of the site, 10 of which are directly below the groundwater gradient of the appeal site and 2 are immediately adjacent to its eastern boundary. The groundwater permeates into the aquifer, which via boreholes supplies approximately 12 houses with their water, hence its quality is critical to the health and well-being of local residents. We know, don't we, that the water environment was very different in that case to this case, based on what we read there, in very short form.
In what way, sorry?
In terms of the height. I can talk. In terms of the hydrological pathways that were identified, for example, the fact that there were springs immediately adjacent to the site boundary demonstrated the permeability of the ground in that case.
The hydrogeological conceptual model is the same. You have a site on top of the hill, underlain with clay with flints, green sand aquifer underneath, potential for migration through the clay with flints, potential for runoff going across the green sand, and springs issuing from the green sand.
We can see from that decision there were springs immediately adjacent to the site boundary at Pound Road, yes?
I don't have that information directly in front of me, but it's the same concept, it's the same principle, that water can get either through the ground or off the site to springs that are issuing from the green sand.
I'm going to try this a different way. You've got the paragraph in front. We're going to have to get on top of this microphone switching soon.
I'm sorry.
Right, if you just keep your finger on that will probably help. On this, we can see, and yes, I accept it's a summary of the case that you were involved in there, but we can see in respect of hydrological pathways that in Pound Road they were both proximate and demonstrated permeability of the ground in that location. That's fair, isn't it?
I think I've established in my evidence that it's the same strata, the clay with flints, and that we consider that it has the capacity to allow water through it. It's the same aquifer, and the aquifer yields springs, which are then used. I'm struggling to understand what you're getting at, to be honest.
In Pound Road, we can see from this paragraph, just read it, 32 identified wells, boreholes and springs in the vicinity of the site, 10 of which are directly below the groundwater gradient of the appeal site and 2 are immediately adjacent to its eastern boundary. Groundwater permeates into the aquifer, which via boreholes supplies 12 houses, etc. The hydrological pathways that the inspector found were present in that case were both proximate and demonstrated there was ground permeability at the site. Yes or no?
The evidence I've given is that
Not a yes or no, Mr. Carpenter.
then I'm struggling to understand the question that you're asking. The hydrogeological conceptual regime is the same. The evidence I've given is that the clay with flints, which underlies the site, allows water to permeate through it, and that there are springs which are hydraulically down hydraulic gradient from the site, which are being used. So I'm not sure, perhaps you could clarify for me which bit you think is in disagreement, and that might help.
Because we're not talking about conceptual, are we, when we're looking at paragraph 54? We learn, for example, that there are immediately adjacent to the eastern boundaries 10 wells, boreholes and springs. Yeah? Immediately adjacent, that's the wording used. Sorry, forgive me, yeah, two of which.
So we have springs that are down hydraulic gradient, that the hydraulic gradient comes from the site. Is it an issue of proximity that you're getting at? Because that doesn't change the pathway. Is it immediate proximity? The pathways are the same.
Yes, I use the word proximate in my question for that exact reason, because there is a difference between. Can you use the microphone, please, Mr. Carpenter? There is a difference between you and Mr. Fellows in respect of the permeability of the ground and the time that it would take for water to move, travel through and over that ground. I can take that up with Mr. Fellows, and I will. Paragraph 21 of your proof of evidence then, please. If you can turn there. What you say there is, we note the appellant and the council agree the site is located in a source protection zone and the site is located in a groundwater protection zone. We in fact agree that they're not, don't we? Do you want to look at the statement of common ground? 4.7.1 is the statement of common ground. If you want to turn within that to page 12, paragraph 6.16. Six point 16 on page 12. You have that. What that says for the benefit of people listening is it is agreed that the site is not located in a source protection zone or designated drinking water safeguard zone. You see that?
Yes, I accept that, yeah.
Those matters are objectively identifiable by looking at the relevant maps, aren't they? Whether the site falls within a source protection zone or a groundwater protection zone, that can be identified by looking at the relevant maps, yes?
The source protection zones around private water supplies are defaults. That's to say, if the Environment Agency doesn't know they exist, they won't be there. If the Environment Agency understands that there is a private water supply and it thinks it's a borehole, they will apply a certain default. So just because the Environment Agency doesn't know a borehole exists, that doesn't mean a source protection zone doesn't exist. It just means it's not on a map.
Let's help the inspector with this. If the inspector wants to know whether or not this appeal site falls within a source protection zone or a groundwater protection zone, one goes to the relevant magic maps, don't they? And you have a look and you will see those areas which are designated for those purposes. And when one does that exercise in respect of this site, one finds it is not in those designated areas. Is that correct?
When using a site like the magic site identifies those source protection zones which have been defined. It is not, it does not contain the information to identify private water supplies and the default 10-metre SPZ around them. There are tens of thousands of these in the country. The Environment Agency is not aware of all of them, so they're not on that map. So to take that map literally, it is incomplete. It is a screening tool used by the Environment Agency for the purposes of guiding its position in terms of developments or what have you.
Yeah, I mean, let's just see how we help the inspector with this. Because there are maps, Environment Agency maps, that can be consulted in order to understand those things, yes?
Yes.
When that is done in respect of this site, it will not appear in either a groundwater protection zone or a source protection zone, will it? It doesn't, it's not there.
It's a screening tool.
Am I correct or not? It would really help Mr. Carpenter, I understand.
Okay, so if you consult it, you will not see source protection zones on or around the site. But that does not mean that private water supplies do not exist, and it does not mean they are not afforded the rights or protections of other water supplies that exist and have source protection zones around them. It's a screening tool to guide locating development, to guide whatever. But like many other Environment Agency screening tools, it will say that these are not site-specific.
I want to try and define the principal disputes between us. First of all, this. In respect to firewater runoff, to the extent that it's contaminated, the aim should be to prevent the escape of that water off-site, yeah? It should be contained. That's what you explained the system is designed to do. And the way that happens is to provide a containment system that can hold any water generated by the fire incident and any additional water that's in the system within a closed system. Yeah, that is primarily a matter of design and, of course, as you've raised in your evidence, maintenance, ensuring that the design works and also that it continues to work throughout the lifetime of the scheme. Yeah.
Including in the design that it's appropriately sized.
Because essentially what we're looking at here is an engineered solution to a potential problem. And what that is at the moment is shown to be is demonstrated on the drainage strategy. That's called document 1.78, which shows the strategy plan. The detailed design of which would come forward at the next stage in discharging the drainage condition, yeah?
The next stage would be detailed design, yeah.
So detailed design, secured by condition. Have you seen the conditions in this case?
I haven't.
You haven't, so you've not had an opportunity to comment on them. I would invite you to do so, Mr. Carpenter, because what we have here is a proposal for a drainage system that is capable of being closed to accommodate a capacity of water, essentially, yeah? That is something that is capable of being engineered and provided at this site, isn't it?
For a certain amount of water, that's right. But the details of the construction of the system only are relevant if the system is large enough. If the system isn't large enough, then it doesn't matter how good your engineering is or the detailed design is, it's still going to overtop.
And whether or not it's large enough comes down to, one of the points is the volume of firefighting water that would be required on the site, yeah?
That's one of the components, yeah.
And of course, I think you've quite fairly said that your area of expertise is not firefighting operational tactics.
Correct.
So the inspector's going to hear evidence about that, but assuming we can reasonably identify a level of water on site, there is a technical solution that is capable of accommodating that on this site, isn't there?
If you had sufficient certainty as to what volume of water might be used, and if you had sufficient allowance for an extreme storm event, then you could contain that. One of the questions would be is whether you can do that.
And we're going to come to look at those different components in due course. But if I can put it this way, there is nothing that you say about this site which is inherently incapable of delivering a drainage system.
But for the system to be effective, you have to have sufficient confidence that you've got the right quantities of water. And that is one of the issues that is clearly uncertain.
The point you make is a general one, and it's not about this site, is it? If the point is uncertain about the amount of firefighting water required for a fire at this BESS facility, it's uncertain for fires at all BESS facilities, isn't it?
I think that's clear from the NFCC guidance, which raises uncertainties about the amount of firefighting water that could be used. And I think it was the very point made by Mr. Blunden this morning, that each site is unique and each site is different.
Yeah, and that's why we need to focus on this site and what we know about this site, as well as the technology that's going to be delivered, which of course is not for your evidence, but is part of the matters for the inspector. We know that obviously battery chemistry is not within your areas of expertise, correct?
That's correct.
Here to give evidence on plume generation, content or direction.
Could you repeat that?
You are not here to give evidence on plume generation, content or direction of travel.
Correct.
And I put that because you make some comments in your proof of evidence about firefighting tactics to bring down a plume cloud, for example, or a vapor cloud, I think you put it. But as you've said, your area of expertise is not firefighting operational tactics, yeah?
My reference to that, I think, quotes another fire service who refers to the need for dispersal of air plumes. So it's a reference to experience or opinion based on another fire service.
Not personal experience. And were you here yesterday, or were you watching online for the evidence of Mr. Blunden? You weren't, okay. What you're focusing on is limited to the consideration of pollution risk to local resident water supplies used for drinking water and non-drinking purposes, as well as more generally the surrounding controlled waters, groundwater and surface water you've dealt with in your evidence. But you can't help the inspector with whether or not firewater runoff would be hazardous. Is that correct?
My evidence includes a assessment of the reliability, completeness, emissions that exist in literature or papers or reports that are referenced by your own experts, by which, if I might give an example to clarify the point for the inspector, if there are no details of where tests or where samples have been taken or when samples have been taken of water, whether it's the runoff water from the site, whether it's fire water, whether it was at the beginning of the fire, whether it was at the end of the fire, whether they were actually runoff samples, whether they were from water wells, whether they specify what they tested or not tested. This is where my proof of evidence talks to other people's information that's presented about runoff water chemistry or fire water chemistry or other related fire waters, and my observations and comments as to what those mean. I don't make comments as to what I think is in them.
Difference between you in terms of identifying what could be in firewater and the reliance on other people's work that helps you understand that. Because do you accept that whether or not firewater is hazardous depends on the presence and also the concentration of hazardous substances within it?
It certainly refers to the substances in it, and the descriptions of whether it's hazardous are specific and are in the proofs of evidence, and I can find one and quote one, but I think you'll have it in front of you. And that doesn't specifically mention quantum. Hazardous substances are to be prevented from going into controlled water courses. That's a clear statement by the Environment Agency. And so, yeah, so there is, it's not about quantities that could have an impact. That's a non-hazardous substance. Hazardous substances are not permitted to go into controlled waters.
Yeah, I mean, we've seen a lot of this through the evidence, and I'm not going to talk about the different chemical components with you, but there are chemicals in water currently, and that water is regarded as suitable for drinking because those substances are at a low enough concentration that the water is safe. Yeah?
There's drinking water inspectorate guidelines and standards below which it's either advisable not to, or in the case of public water utilities, they're not permitted to.
It's not just the it's not just the presence of certain components, chemicals, whatever it might be, within water that makes it hazardous. It's the concentration of those elements that makes it hazardous.
With respect to controlled waters and the position of the Environment Agency is that hazardous substances should be prevented from going in. So that's quite binary. That's not specific. Clearly, there are limits on what public water supplies can achieve in terms of their treatment, and so there is an acceptance by the Drinking Water Inspectorate as to what is permissible on that basis. Yeah.
Why we have standards and thresholds, isn't it? Because what that implicitly acknowledges is that there is going to be, or there are going to be some elements in the water which we'd all rather weren't there, but which don't bring about a harm to human health, for example.
Yeah, I think that's probably true.
And the scenarios that we're talking about are scenarios where vast quantities of water are used, and they are so vast that they cause the drainage system to overtop. And of course, there is necessarily a diluting effect then on the water, the fire water runoff from site. Yeah?
Of course, yes.
So dealing with the pathways and the receptors that you address, dispersal of airborne emissions using spray beyond the site boundary, Mr. Blunden has given evidence that it wouldn't be normal operational firefighting tactics to do so. You don't rely on any firefighting guidance that says that would be an appropriate operational tactic for a best plume.
For the use of, just so I'm clear, for the use of fire, for the use of water by the fire service to help disperse a plume. That's your question. I think I answered that already, which is that I refer to another fire service which specifically put that into a statement or response, I think, to a best site, saying the need to their estimate of water to address the escape of plumes of contaminant or plumes of substance, which would be extended because of the let it burn strategy. Off the top of my head, I think they talk about 5,500 cubic meters, which is an order of magnitude more than what the 280.
The 280, that's not the appellant's figure, that's in the latest version of the National Fire Chief's guidance, isn't it? That's the earlier guidance, yeah. It's in fact, that level has decreased in the latest guidance, hasn't it?
It's the quantity of water that, I mean, and this is where I think we need to be quite specific, and this is what I was talking to in my evidence in chief, is that it's the amount of water that the NFCC proposes is no less than that amount, additional to what the fire service will be using. So it's quite specific in that regard. It's not the sole, they're not saying it's the sole amount. So applying with NFCC guidance is therefore applying with having no less than that amount available on site. It's not saying that that's the total amount of water that fire services will use. And the guidance, I think, goes on to talk about different numbers of hours and and quantities being a function of size and layout and a number of other factors.
The next point you make that I want to talk to you about is the capacity of the drainage system and containment failure. Can we turn, please, to assist with that, to Mr. Rigby's rebuttal? Okay. If we go to page 8 of that rebuttal, you will see there terrace connectivity and hydraulic behaviour, which you set out in part in your evidence this morning under section 3. And there's a drainage schematic at the bottom of that page. Do you see that? Yeah, and we know that there are 2 zones, and when we compare that to our strategy at core document 1.78, we can see that zone 1 is made of the upper terrace and the drainage basin, and the remaining 2 terraces, the middle and lower, they're in zone 2. You see that? Zone 1, the upper terrace and the pond, an attenuation basin, we know that the basin alone has a capacity of 765 cubic metres. Yeah. That is, just to put this in the same way that you did in your evidence in chief, that's 3.4 times the old requirement for 1900 litres per minute for 2 hours. Or to put it another way, 7 hours of continuous firefighting, assuming no recirculation at all, in capacity terms.
I will accept it. I mean, the maths and division I haven't done specifically, have it in front of me, but it is, that volume is, roughly that. Yeah.
And if there is a fire on the upper terrace, then that drains to the attenuation pond, which is then sealed off from the off-site water course by a penstock, yeah?
Correct.
The capacity in the upper terrace is also available in addition to the drainage pond, and that's the difference between the total system capacity, or if we have a look at the capacities that are given in the rebuttal. So we've got those at table 1 on page 10. So those are the primary containment features. But we also have the upper terrace drainage blanket in addition to that, yeah? And that is, when you add that in, that's what takes the system capacity as a whole to the 2,393 metres cubed figure on page 3 of the rebuttal in the executive summary. So page 3, executive summary, you'll see the bottom figure there. The total system capacity is 2,393 cubic metres, metres cubed. You see that? Yeah. Yeah. So what we know, where that gets us, is that the capacity across the whole site is sufficient to accommodate 2,393,000 litres of water.
Correct.
And to put that in the terms that you did, that would be 26 hours of continuous firefighting deployed at the rate set out in the NFCC guidance.
But that amount of water is not available for firefighting. So that is to say that you have a best fire on one of the terraces, not all of the terraces. So it is a volume, and you can divide that by 25 litres per second if you wish, but that doesn't mean that that volume is available for firefighting, which I think is what you're implying.
Yeah, that's the capacity across the whole system, and we know that it's in zones essentially. We've set that out in the schematic. So we'll come to have a look at the way in which those two things work, but we know that that's the entire capacity in the whole system. The upper terrace, let's go back to the figures that have been provided by Mr. Rigby's rebuttal. So we know the upper terrace has the capacity of around 1,000. The second zone, that's the two terraces, middle and lower. Together they have a capacity of 628 metres cubed, yeah? That's what we see on page 10 of Mr. Rigby's rebuttal. Yeah? Yeah. And the lower we can see there is 314 metres cubed. And what Mr. Rigby says that in all zones, the 228 metres cubed is exceeded. And we can see the multiplied figures there in the right-hand column of that table. Yeah?
Correct.
And that, as we've identified, the 228, that was the figure in the old NFCC guidance to which the scheme was designed. Now the correct figure for that is actually 180 metres cubed, correct?
Correct.
You made a point earlier about firefighting, and again, I'm sorry you weren't here for Mr. Blunden's evidence yesterday, but it was about how long firefighting had to go on for. And one of the things that you referred to was the large-scale fire testing, and you said, well, that went on for, 8 hours or so. You're aware, aren't you, that in that large-scale fire test, no fire water was applied at all for the duration of the test?
That's correct, yes.
There was, throughout that test, no requirement for any boundary cooling to be applied.
I think that's correct.
So the question happens, or the question is here, what happens when there's already water in the system, and how is water moved around in a fire incident to ensure that the system has sufficient capacity? And I want to just explore that a little bit more with you, because we know that recirculation of fire water is now more than a theoretical concept. It's something that's taken place at Tilbury, for example, yeah?
It is, yeah, it's more than a concept, that's correct.
And more than a concept, it was a concept at the time of Pound Road, when you appeared at that inquiry. It hadn't been tried and tested. Now we know it has been tried and tested, and it's been used to good effect. It was effective at Tilbury. Agreed?
I know it was done at Tilbury. I don't know the extent to which it was effective. I'm not sure I've seen that evidence, but I'm not disagreeing with that. It's reported that it was done.
Yeah. The firefighting tactics have changed significantly over the past few years, from a position whereby it was assumed continuous boundary cooling would be needed, but also extinguishing of the best unit that was in a fire event, yeah?
That's my understanding, yes.
Now the advice is emphatically not to apply water to best containers that are experiencing a fire event, yeah?
That's my understanding, correct.
And the extent to which there would need to be boundary cooling will depend upon the particular circumstances of the site, the information that's available to the respondents. But there is no presumption that it would need to be continuous throughout the fire event, is there?
I mean, that falls outside of my expertise. I think Professor Ramsden probably talked to this. As you know, my evidence is focusing on looking at some of the assumptions and some of the wording that's specific to the NFCC, and whether the 228 or the 180 is, what are the assumptions that are made around that in terms of the NFCC. It's not within my expertise to comment on the large-scale fire tests and the specifics of explosion and whether that results in boundary cooling being no longer occurring and so on. That you should direct to Professor Ramsden.
Yeah. Well, Mr. Ramsden's been, I'm not going to direct any more questions his way. The point that you've made in respect of the recirculation of firewater, I think, is that the tankering off locations would provide insufficient flow for water then to be transferred directly for boundary cooling purposes. Have I understood that correctly? Because the tankering off locations are not the only points where water could be taken from, are they? There's the attenuation basin. If that held water, that could be used as a source of, or a location for recirculation of water. There are the manholes within the different terraces. Water can also be taken off from those points, and not only recirculated for use for boundary cooling purposes, but also to be used for moving water around the site to the extent that it was necessary to achieve containment.
If the fire wasn't in the upper terrace, then you wouldn't have firewater in the basin. If it was in the middle terrace, then to get to the lower terrace, it goes through an orifice. That flows at 4 litres a second from the middle terrace to the lower terrace. So you would be restricted in what you could take. And I think Mr. Rigby refers to taking hours or even days for that water to get into the lower terrace. For you then to be able to access it from the tankering point that's identified. Locations of manholes, I can't, I don't have a specific memory of, but there's nothing that's in the documentation to suggest that a manhole could be used for tankering, for abstraction for tankering. You have specific tankering points that you identify.
I'm not suggesting that they're used for tankering. In terms of the recirculation of firewater, which we agree is or has been used, it is now or has been accepted in respect of a best fire for recirculation. In order to accommodate that recirculation, the point you've made is that the tankering off points don't give sufficient flow, wouldn't give sufficient flow. But we know that the points, the throttling points between terraces also wouldn't give sufficient flow because they're designed to attenuate the flow of water as it moves through the system to slow it down. But there are other points within the drainage system where water can be taken and recirculated, as I said, not just for the purpose of firefighting, boundary cooling, but also for moving water between different zones of the drainage system should it be required.
I mean, to move that water around, you're going to have the ability to access and the ability to pump. The tankering points, which you can use for tankering, are also going to be locations where you have infrastructure for actually accessing the water and being able to attach to whatever infrastructure you need to be able to abstract it. So the ability to take water out of a manhole it's not clear whether that's viable, feasible.
Viable or feasible? It was viable and feasible at Tilbury because recirculation of firewater was managed. It is possible at the detailed design stage to manage those conditions to ensure the recirculation of water that's been used for firefighting purposes or happens to be in the system as a result of rainfall is available for that purpose. That is technically possible, isn't it, Mr. Carpenter?
Unless we have an understanding of the infrastructure at Tilbury, I don't see how we can make a comparison. We don't know whether it went into pond, which, as you said, would be easy to take water from, or what the rest of the drainage infrastructure was. So how easy it was at Tilbury, I don't think has relevance to this site.
Well, Tilbury was a closed drainage system in which firewater was caught and able to be used for recirculation for those purposes. The same principles exactly apply here. A closed drainage system closed off by penstocks in which the water is contained and will be available within that closed system for recirculation should it be required.
My point is that if Tilbury went to an attenuation pond, you can access it easily. So that's not the case here. If you have fire water falling on the middle terrace or the lower terrace, they don't go to an attenuation pond which you can access readily.
No, because we know that it's zone 1 and the upper terrace that goes to the attenuation pond. So that's one source, but we've got the second zone. So just so I can understand, so I can put this to Mr. Rigby and he can explain the point. Is it your evidence that one would not be able to take water out of the middle and lower terraces for the purposes of recirculating for firewater? You're saying that that is technically impossible?
I'm saying the water that comes out the lower terrace will flow out of the lower terrace to the penstock, and you'll be able to take it out. The connection between the middle terrace and the lower terrace is an orifice plate. So I'm saying the opportunity to take that out there, in terms of if the information were available, I don't understand how that would happen.
I haven't suggested that it's taken out of that particular pipe work, which is...
So I thought you said you were able to access the water in the different zones across the site too.
Because there's manholes over the site and drainage infrastructure that can be accessed. In order so that the equipment can be looked at, so that it can be monitored, so that it can be maintained. There are points at which the water can be accessed through manholes.
I guess that depends on the purpose of the manhole. If it goes down to a closed pipe that's running through it for whatever purposes, then you won't be able to access it. If the water goes into a manhole and the manhole is open and the pipe goes in one end to another with a sump in it, then I guess you could, subject to how deep this shaft was and so on. It depends on the purpose of the manhole, doesn't it?
Microphone. That's the point, isn't it? Because what we have at the moment is a strategy, a water drainage strategy, that will be subject to detailed design, and which is why I've invited you to comment on the conditions, so that in the event planning permission is granted, the system that we have is robust and capable of doing what you and the appellant agrees it should be doing. Do you see?
I understand the point you're making, yes.
There's another point that you make, and you've made it in your evidence as well. And it's about the need to design for a fire event during a storm of a magnitude, a 1 in 100-year storm event. You made that point in your evidence. A 1 in 100-year storm event is an extreme weather event, isn't it?
Yes.
And the need for boundary cooling at all in a storm of that nature would of course be questionable because of the amount of water coming down on the site to start with.
I don't think you can arrive at the conclusion. You don't know how much water's coming down. It's a natural event. So you wouldn't be able to manage the fire by assuming you didn't have the need for boundary cooling. You wouldn't have any idea what the thermal benefit would be of any particular rainfall event.
Your evidence is, again, so I can put it very clearly to Mr. Rigby, that in a 1 in 100 year extreme weather storm event, the need for boundary cooling would be the same as if it were entirely dry.
What I'm saying is that at the time of a fire, you would have no idea that there was going to be a storm event, and you would have no idea what the size of that storm event was going to be. So to manage the fire on a presumption of how much water was arriving at the time you were managing the fire is not going to happen. I accept that if it's raining, that will have that will change the baseline scenario, but you wouldn't be able to work on that basis.
Because what we're looking at there is the 1 in 100 year storm event is there's a 1% chance in any given year, yeah?
It doesn't work like that. That's not how it works. There's not a 1% chance in any year. But for the sake of keeping things simple, it's a rare event which is, may happen of that frequency. It's actually more likely to happen than 1%.
Right, so you don't accept that as a definition. Again, just so I can be really clear when I'm making my submissions, that Mr. Carpenter doesn't accept the definition that a 1 in a 100 year storm event means there's a 1% chance of that storm happening in any given year.
A 1 in 100 year event.
Please use your microphone.
Okay. But the probabilities, and I don't have the formula in front of me, is that it doesn't work quite like that. It is a rare event, an extremely rare event of the order of the percentage you're talking about, but it doesn't quite work out that way.
Okay, well, I can take that up.
But it's for the purpose of this discussion, it's a de minimis issue.
A de minimis issue, that's helpful because it's really important to understand what we're planning for and whether that's a reasonable scenario to plan for. Because Professor Ramsden's evidence yesterday was that there is less than a 0.5% chance of a battery fire happening in any given year. The chance of both of those events, that is a 1 in 100 year storm and a battery fire happening concurrently, is remote, isn't it?
The likelihood of a best fire is outside of my expertise. I can't comment.
You rely on Professor Ramsden's evidence for that, I assume?
His evidence is what he has presented to you. My proof of evidence is focusing in on the assumption that a best fire occurs, and then what's the likelihood of it reaching receptors? If my work doesn't work on the basis of there being a best fire, then there's no from an Environment Agency point of view, you're assuming that and allowing for there being a risk that you're having to mitigate.
What I'm putting to you at the moment is having to plan or how appropriate it is to design a drainage system based on the possibility of two rare events coinciding? Do you see the point?
Yes, I get your point.
And the guidance that we went to today, in terms of what we should be planning for in terms of capacity, that we went to this morning from this very large, voluminous text, so far as I can see, that is not prescriptive as to what should be planned for. There is an element of judgment involved by the designers and engineers involved, and of course other stakeholders, as to what should be planned for in terms of capacity. Is that fair? Containment systems for the prevention of pollution.
Yeah, it's a construction industry document, so it's. Please do.
The document is not prescriptive as to the capacity that should be planned for in any single event on any particular site, is it?
No, it's guidance.
And with guidance, there is inevitably a matter of judgment that has to be applied as to the drainage system capacity that's planned for. Do you agree?
Industry guidance is there for a reason. Whether it's codified to being a standard is another matter, but you would have to have good reason as to why you weren't following guidance.
Mr. Carpenter, if you can engage with the question I ask you, because that's a qualification and I need an answer, because if you don't answer me, I'm going to ask you the question again, and it takes us twice as long. So make the qualification, but please answer the question in the course of doing so. What I put to you is, because there is not a single prescriptive standard in respect of a scheme like this at a site, at this specific site, there is inevitably an element of judgment involved by the experts, that is the engineers and technical experts involved, as to what the capacity should be.
That's true, but it will also be true of the statutory consultees who are going to take a view on whether they consider what's presented is adequate or not. The Environment Agency refers to a maximum rainfall event, so they will have a view on what that means and whether that means a 1 in 2 year, a 1 in 10 year, or 1 in 100 year. But we know what they mean when they're referring to flood risk.
And we know we've got no statutory consultees that are objecting to this particular scheme, have we?
That's correct.
One of the points that I wanted to take up with you as well was the 1 in 10 year point. The 1 in 10 year point within this guidance doesn't include an allowance for climate change, does it?
I don't think so.
This site has been designed on the basis of plus 45% for climate change, yeah?
It has, yeah.
Thank you very much. I want to turn then to the dispute about permeability of the clay with flints underlying the site. And what you say in your rebuttal, page 2.6, is that the information demonstrates that the clay with flints allows water through it at sufficient speed to reach the aquifer within weeks or months and may reach sufficient depth to prevent viable excavation within days. That's essentially the point you make about the rate at which water can travel through the clay with flints. I want to go to core document 1.29, please. That's the flood risk assessment. And to the soakaway test report, it begins on page 35 of the PDF. Or, madam, do you have it in hard copy? No. No, you've got it PDF. So that's page 35. We've got the soakaway test report, and the ground investigation undertaken there was specifically undertaken to determine the permeability of the ground of the site itself, yeah? Which is directly linked to permeability, correct?
It is.
Thank you. If we go down to 3.3 and 3.4, we learn that 2 trial pits were excavated to 2.5 metres to observe groundwater and excavation. To observe groundwater, and that excavation was regarded as challenging, such that a 6-ton tracked excavator had to be used.
Yes, I can read that.
And it's right, isn't it, that the water level and inflow into the trial pits is consistent with discontinuous perched water rather than being indicative of a productive aquifer.
Sorry. Table 4.1, which is on the next page, under section 4.3, identifies that there's water flowing into the trial pits at different depths, confirming that there's water in the strata, which means it got there.
Yeah, it got there. The question is, how quickly did it get there? Yeah? That's one of the factors which is important in this case.
That's right.
And we can see there at the occurrence of groundwater table 4.3 that you've gone to, that we've got rate of inflow is slow, moderate, slow and slow. Those are the values that were returned.
Correct.
Then we've got the soakaway test results at 4.4, and we've got 7 trial pits that were dug in order to carry out this test. You said in your evidence that they didn't drain in 1 to 2 hours, suggested that was a short test. But actually what we can see from the results is that the longest time that one of those pits was observed for, the duration of the test, is TPO1, and that was 246 minutes, yeah? So that's 4 hours, during which time there was no soil infiltration at all.
If there was no drop in water level, which I can't remember for every test, then that would be correct.
Yeah. Well, have you got it in front of you? Because the results are set out there. TPO1 to TPO7. Total recorded fall of water. Yeah. That indicates that certainly in respect of the site, the clay with flint strata that sits below it is of low permeability. Agreed?
It demonstrates that at the locations of the trial pits, that the permeability of the clay with flints was not high. Okay, let me put it another way. It doesn't demonstrate that the clay with permeability was sufficiently low that rainfall over a sustained period of time doesn't infiltrate into it, which is backed up by other sources of evidence, which is the groundwater level hydrographs going up and down, and the recharge to the springs, which can only be water balance of which only works if water can get through the clay with flints. I'm not saying that it doesn't inhibit it. I'm not saying it goes in as quickly as it would do if it was on the exposed sand. But what I am saying is that the water has to be able to get into and through at some extent in order to explain that you have flows in the springs. And you have water in the trial pits, which demonstrates that water got there.
Is suggesting that water never entered the clay with flints. What we're looking at is permeability and the time taken for water to travel through that strata. So please engage with my question again, Mr. Carpenter. These test results specific to this appeal site demonstrate low permeability in that clay with flint strata, don't they? Yes or no?
I'm not trying to be difficult here, but low is a relative term. Low as in they won't enable soakaways? Yes, absolutely. Low as in they won't allow water through to support the springs. The evidence that the springs are there suggests otherwise.
Yeah, I'm asking you about the site specifically and the test results for this site. I need you to turn your microphone off, Mr. Carpenter. I'm asking you specifically for this site and the results for this site, because there is no better evidence, is there, of the site's ground permeability than the site-specific report and the results from these 7 soakaway tests. There's no better evidence about this site, is there?
The trial pits are the only investigation that has been undertaken on the site.
I'm going to ask my question again, and the same rules apply, Mr. Carpenter, that we will be taking much longer if you avoid them. The evidence set out within this report from the soakaway test results is the best evidence of this site's ground permeability.
Correct.
Your point is that over the aquifer as a whole, so looking at the much broader picture, that there must be some water that travels through the clay with flints and makes its way to the aquifer. And that evidence is demonstrated. You've got some evidence from the 50s, 60s, and so on. That is a calculation undertaken over a very wide area, of which the appeal site, if it does contribute, would be an insignificant proportion.
Water balance calculation, which Mr. Fellows has misunderstood, demonstrates that water, the catchments of the springs will include the area under the site. The area of the site is going to be a small amount compared to the overall catchment area of the springs.
I said insignificant. Do you disagree with that?
I don't think I can be as specific as that and use that word. It's a small percentage. I guess whether it's insignificant or significant depends on the purpose of the question, such as the amount of contaminant that could get through and what that means in terms of the water quality arriving at the springs.
I'm talking about quantum. So if we're talking about contribution to the aquifer, the exposed green sand, which will allow rapid transportation of water through the strata, is going to be a much greater contributor than the clay with flints.
It'll be easier for the water against the green sand, but the outcrop of the green sand, the area that's exposed, is much less. Yeah. So the water balance will be a combination of more recharge per square metre getting into the green sand outcrop and less per square metre getting through the clay with flints, which we can accept is heterogeneous. it's a combination of the recharge rate per square metre, but also the area that's exposed. So the area that's exposed to the green sand is considerably less. So it's a combination of those two in terms of contribution to the spring yield.
Certainly, I think Mr. Fellows calculated that the exposed green sand was contributed 25%. That was his calculation.
You'd have to take me to the relevant part of his proof, sorry.
Yeah, it's 2.2.13 in his rebuttal proof. .13 of the rebuttal proof on page 6. Well, he says that in vicinity of the site, the outcrop of the upper green sand formation is approximately 25% of the total area of formation and is therefore likely to contribute significantly to aquifer recharge from direct rainwater infiltration and leakage from surface water courses. Do you disagree with that at all?
I agree that it's exposed. It will get rainfall recharge going into it. It will get runoff from the overlying clay, but it'll also have runoff from the rainfall that's landing on that will also go down the hill because they tend to be quite steep, the locations with the green sand. Whether it's 25%, I don't know. We'd have to look at it. But okay, well, Mr. Fellows has misunderstood what I wrote. He thinks I'm talking about a single spring and a radius around that spring. What I was referring to was all of the springs and an area that contributes to them. And that area would have a radius of the measurement I gave in my proof of evidence. I didn't say it was a radius around the springs. I didn't say it was just for the springs. So the area of exposed green sand that is relevant is that is sitting above all of the springs, and as a percentage of the area, it's that relative to the clay flint that's in it, or in their catchment. So he's using the wrong location and therefore the wrong geology to arrive at his conclusion.
I'll let Mr. Parkinson have that fun with Mr. Fellows next week, and he can tell him why he's wrong. When was the last time you visited the site?
Yesterday.
Did you go onto site?
I went around the boundaries on some site where there's public access.
Right, so you didn't go onto the site itself?
No, I didn't encroach onto private land, no.
Have you ever been onto the site? Of course, you would have had to have asked permission, but have you ever been onto it?
No.
So you can't help with that point then? Okay, that's fine. The appellant, through the evidence of Mr. Fellows in his proof of evidence 3.6.8, calculates that the time for water to flow vertically through 1 metre of clay is approximately 1 year. And I haven't seen you challenge the calculations that he provides. Do you accept that they're accurate?
No, just a failure to challenge it doesn't mean I accept it. The evidence I provided is that I consider that water can get through the clay with flint. So I would disagree with his conclusion. Can you direct me to the relevant part of his proof or rebuttal?
Yes, it's 3.6.8 of Mr. Fellows' proof of evidence.
So it looks like his calculation is based upon some assumed hydraulic conductivities of the clay. And those
Just a
hydraulic
second,
conductivities are,
Just a second, Mr. Carpenter.
sorry. It looks like he has taken some hydraulic conductivities for clay, which he references the CD 12.7, which I'm going to guess is the Dominico core document. So, and some of these are exceptionally low, but they look like they are reflective of a deposit that is 100% clay, rather than the geological logs which describe the clay with flints as silty, sandy, gravelly clay or silty, gravelly clay. In other words, they have sediment in them that's coarser and therefore more permeable than a pure clay, or a clay that's been engineered or compacted to, say, to form a liner. So he's making certain assumptions here on the permeability of the clay, and I'd have to try and back calculate them, but they look like they're extremely pessimistic values.
I'm interested because one of the matters between us is how fast any water runoff from site, assuming that containment fails, how fast any water from site would run through the clay with flints. And you haven't provided an alternative calculation as part of your evidence, have you?
So you were saying that if water... I haven't provided an estimate of permeability. The speeds of travel can be insights on the speed of travel can be gathered from the reliability of the springs not drying out in the summer, and the hydrographs showing that there are responses during winter period. So if that water wasn't coming through in years, I think he says, then you wouldn't see that seasonality in terms of the groundwater levels going up and down. So I think he's using values that are extremely pessimistic. I think they don't reflect the descriptions of the strata, which are of silts and sands and gravel in it, and they're not supported by seeing the seasonal trends in groundwater levels that have been observed in a borehole that is under the clay cover.
The point is that in this area, in terms of the strata overlaying the aquifer, it is not completely clay capped, is it? There are outcroppings of exposed aquifer, which are where there are permeable areas that can accept water ingress, or accept water through rain, whatever it might be, runoff.
Yeah, the green sand outcrop is a good example of that. And in my evidence, I explain why a water balance means that the outcrop is not sufficient to explain the flows in the springs, or the groundwater level variation in the borehole that's overlain by clay with flints.
So I want to then deal with worst case scenario. So let's assume that everything's gone wrong. Water's running off site, that is fire water. Actually, hang on, just bear with me a moment. Yeah, so fire water escapes that's been used for the purpose of boundary cooling. It is right, isn't it, that the fire service would be in attendance and could reasonably be expected to take measures to contain contaminated water.
I think the NFCC guidance says that they would try to, or at least maybe it's responses. I don't think it's not their it's not their responsibility to do so, but yes, they would use their best endeavours to do that. But it wouldn't be a primary objective.
The Environment Agency would be notified of the incident, yes?
One would assume so, yes.
And they would, as part of their statutory duties, take action to protect impacts to groundwater and surface water.
Within the timescales of a fire, what they can do practically, I don't see how that would have an impact on the protection of the environment.
No, we're assuming that runoff has happened. That's the premise for these questions. Gone wrong, runoff has happened.
Yeah, and left the site. Is that what you're saying? And left the site.
Yes. Yeah, in such an event, if the drainage system had failed, the EA would be notified in the aftermath of a fire event, yes, and would take action to protect, so far as they could, impacts to groundwater and surface water. Well, they're not doing their job, are they, if they don't, Mr. Carpenter? It's part of their role, it's part of their responsibility.
They are a regulator.
Yeah.
Their capacity to actually clean up contamination is limited.
Let's take it step by step. The Environment Agency could reasonably be expected to initiate testing of the surrounding area to determine if there was contamination.
Potentially. I'm not sure if it's reasonable or not. That's just my opinion.
I think the Environment Agency is notified of an incident where there's runoff of firewater from a BESS facility and they're going to do nothing about it.
No, that's not what I'm saying. What I'm saying is I don't know if their response would be to test in that scenario. It's just my opinion. I'm not saying they would or wouldn't. I'm just saying I don't know if they would.
The local authority has a duty to assess risk to private water supplies in its area, doesn't it?
It does.
And the operator of the site would also have duties arising from statute, from common law, to remedy any potential contamination or face, in some instances, serious fines.
I suspect so, yes.
The point is that if contaminated water did leave the site, assuming everything has failed, which is not the appellant's case, but for the purpose of this question, let's assume that is so, there is no foreseeable way, is there, that members of the public wouldn't be informed and appropriate tests carried out to understand if water supplies had become contaminated?
One would expect that the environmental health department unit would take samples from the boreholes, wells, springs used by, especially by people, and test them, yes.
And to the extent any contamination existed, of course, that would be a matter for the operator of the site to remedy.
I think you referred to common law and others, so as having a duty of care, then I think that's probably a reasonable conclusion, yeah.
Thank you, those are my questions.
Mr. Carpenter, I've just got one question. You were asked about the report which said the 1 in 100 year assessment compared to is it 1 in 10?
The 1 in 10 year is mentioned in this Syria guidance document. The 1 in 100 year, I'm not sure what the question was specifically. The 1 in 100 year is the storm event that the Environment Agency uses to, they want designs to address an event of that magnitude. So when you're designing a drainage scheme, that's what you design for that risk. The appellant has presented evidence that the storm that they're allowing that is coincident with the best fire is a 1 in 2. The Syria guidance says 1 in 10 for the storm event, but it also says for the accumulated rainfall, so the amount of rainfall that is falling over the period of the incident, which is unknown, and for the 8 days after, which presumably reflects a period of time for clearing up the site, removing debris and so on, and that the rainfall that falls in those 2 periods has to be on the basis of a 1 in 10 year return period. In other words, it's not average rainfall, it's rainfall over those durations that occurs once in every 10 years of that frequency. I'm not sure if that answered your question now.
Yes, it does. Thank you. And Mr. Carpenter, are you only here today? Because I think I heard that you said you hadn't looked at the conditions.
I'm here tomorrow as well.
Okay.
I'm here tomorrow morning for certain when Mr. Rigby gives his evidence, and depending on counsel and client, I may be back next week for Mr. Fellow's evidence. I don't know at this point.
Okay. I'm not going to ask you any questions at the moment about the conditions because you obviously haven't looked at them. I do think it's important that you do look at the draft conditions. Ms. Osmond-Smith took you to conditions relating to detailed design. I've also raised a question about the balancing pond in relation to landscape. So I'm not going to ask you any more about that, but I do think it's important that your team is working together collectively on these details. I'll leave it at that for now. So no other questions. Thank you.
Thank you, Madam. And yes, we have looked at the conditions and we've discussed the ability of conditions to resolve concerns. I think we haven't looked at, or Mr. Carpenter hasn't looked at the exact condition, the wording that's proposed here, but the concept of whether conditions can resolve the concern has definitely been discussed, and Mr. Carpenter dealt with that in his answer. But yeah, we'll make sure that if Mr. Carpenter isn't here when we discuss conditions, I've taken instructions and can pass on his comments.
Yes, thank you, Ms. Parkinson. You saw inside my head there. That's exactly what I was getting at. Thank you very much.
Thank you, Madam. Mr. Carpenter, I think I'll probably go, I've got a few questions in reverse order. So do you remember you asked some questions at the end about sort of post-event remediation? So once, if there are contaminants, if they've gone off-site, the ability to remediate. Can you turn to your proof at paragraph 30? And you quote there, about 4 lines down, to the EA's approach to groundwater protection, which says, if an activity may cause serious or irreversible damage, the EA will adopt the precautionary principle and assess circumstances using a potential worst-case result. This is because once polluted, groundwater may take years to clean up. You, the developer, must prevent hazardous substances from entering groundwater. And then it goes on to set out the legal definition of hazardous substance. And can I just have your opinion on how consistent relying on post-event remediation is with the precautionary principle as set out by the EA there?
I think the EA, in some of its responses to other sites, the EA, in their response on other sites, and these are included in the appendices of my proof, have raised concerns about the potential for contamination of the drainage system, like pipes and gravel packs and so on, and that the drainage system does not discharge stormwater from it until such time as it's been demonstrated to be clean. So I think that raises some questions in terms of the precautionary approach, especially for hazardous substances, because they do not want them entering the groundwater, but that can equally mean the controlled water, so surface water as well. They don't want any entering. It's prevention. It's not, a bit, which means that they will want a precautionary approach taken in terms of the ability to clean the system. And I think that poses some particular questions in terms of the gravel blankets. Like, how would you be able to demonstrate that they've been cleaned adequately? How would you clean them? Could you clean them at all if you've got infrastructure sitting on top of them? Would you have to excavate and remove some of the blanket to get rid of contaminants that had bound themselves into the gravel pack? So I think it raises some significant questions in terms of whether it's actually feasible to remediate the gravel blankets if the water that's coming out of them is continuing to demonstrate that it has contaminant in it.
Thank you. And I think the way the questions were put were on the basis that the water's gone off-site. So no, that's fine. So if you can deal with the precautionary principle in that scenario, so water's left the site, and how consistent is it? How much weight should we place on post-event remediation in that scenario?
We haven't discussed it specifically during my cross-examination or the evidence in chief, but other experts and other references refer to substances like called PFAS, which I suspect come up already, which is a hazardous substance, described by the Environment Agency as being, using this definition, and it is toxic, it is persistent, and it bioaccumulates. So it will get into the wetlands and the ecosystems, the plants and so on. So there will be the existence of these kind of compounds in the local environment for a long period of time will be, that possibility is going to remain, and that is going to, I think, cause the Environment Agency some concerns about how it could be mobilised at a later point. There is PFAS already existing in the watercourses in England generally, and I think it's been demonstrated that it's in and around this environment. So the addition of any additional substances on top of that baseline is going to make it more likely that it's going to start to reach a limit that's not acceptable for drinking. So, so the Environment Agency is going to be concerned about the presence of that water, presence of those substances in the groundwater watersheds for a sustained period of time.
Thank you. You asked some questions about recirculation and the ability to effectively move water from terrace to terrace during a fire event. Have you seen anything from Devon and Somerset Fire and Rescue Service to indicate that they consider that that would be acceptable on this site? Just a small point, but just to clear it up. Do you remember you were taken to your proof? You don't need to take this up again, but your proof at paragraph 21, where you say, we note the appellant and EDDC agree that the site is located in a source protection zone and a groundwater protection zone. Can you go to CD 4.7, which is the version of the statement of common ground before the council, between the council and the appellant at the time? Well, let's take it up first and we'll see what it says. So it's CD 4.7, it's the previous statement of common ground between the council and the appellant. It's on, the paragraphs are not well numbered. It's the penultimate page. It's under the heading Fire Safety and Pollution. Yeah, and we can see here, it's agreed that the site is located in a source protection zone. It's agreed that the site is in a groundwater protection zone. And if we look at the bottom, it's signed by the council and the appellant. Now, we've heard what you said about the mapping, but at the point at which you wrote the proof, is this the document that you were referring to when you put brackets statement of common ground in your proof as it being agreed between the council and the appellant? No. Okay. And in terms of the position at Pound Road and whether that site was shown as being located in a source protection zone on the EA mapping and ditto groundwater protection zone, was that site in the same position or a different position to this one?
I can't remember, sorry.
And ditto, and if you can't remember, I could take it up with Mr. Jones. It was put to you that there's no objection from any statutory consultee here. Can you remember if that's the same or a different position to Pound Road?
I can't remember, sorry.
That's fine, Mr. Jones will remember. Okay, thank you, Mr. Carpenter. Those were my questions.
Okay, Mr. Carpenter, you're released. Thank you. Okay, we have nearly 3:30 on the clock. Shall we take a short break and then do we go to Mr. Reynolds then?
Yes, we do. And I'm going to hand over to Mr. Byers. He's going to lead that evidence on behalf of the appellant for this part.
Okay, so how long, Mr. Byers, do you think we're going to be in examination in chief?
I would have thought 40 minutes or so at most, 45 minutes.
Okay, so if we take a break now until 22 on the clock, a 15-minute break, is that enough for everybody? Are we okay with that? And then just before we finish up today, there are just a couple of housekeeping matters, short ones, but don't let me let you all run away before we've done them. Okay, right, we'll adjourn now. Thank you. Okay, ladies and gentlemen, I think we've got 22 on the clock in the room. And so, Mr. Byers, would you like to call your witness, please?
Yes, thank you, Madam. Good afternoon, Mr. Reynolds.
Good afternoon.
Could I ask you first to read the oath that you should have in front of you?
Yes, certainly. I do solemnly, sincerely, and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you. Before I introduce you, I'll just give you the core documents that I think we'll be going to. So it will be your own proof of evidence at 6.7. Professor Ramsden's rebuttal proof of evidence, which is core document 15.2. The site safety report, which is core document 1.36. The Carrington Best verification and compliance report, which is core document 9.6. And the EPRI report on Carnegie Road, which is core document 9.5.
Can I just check? Can the public at the back of the room hear okay? No. Do you want to come forward? No, you want to stay where you are? Okay, can you try with a bit louder with the microphone?
Certainly. Mr. Reynolds, I'll just introduce you by reference to your proof of evidence, paragraphs 1.1 to 1.3. So you are a scientific advisor specialising in hazardous materials. You say that you're a fellow of the Royal Society of Chemistry and the Chartered Institution of Wastes Management and a chartered scientist and chemist. You have more than 35 years experience working with hazardous chemicals and 15 years experience of managing the risks of lithium-ion batteries, including fires and thermal runaway. You work with regional fire and rescue services as a consultant and on-call hazardous materials protection expert, which includes attending major fire incidents alongside operational fire service crews. Through your work as a scientific advisor, you've attended incidents involving lithium-ion batteries of various sizes, and you have supported fire and rescue services to develop their procedures for dealing with these incidents. And you confirm at 1.4 that your evidence has been prepared in accordance with the code of conduct of your professional chartered institution, and the opinions you express are your true and professional opinions. Is that all correct?
Yes.
Thank you. I understand there's one point of clarification that you want to make in your proof of evidence, which is at paragraph 4.1. Which appears on PDF page 15 and internal page 15. Can I just ask you to set out that clarification, please?
Yes, so in paragraph 4.1, it talks about my attendance at best fires. So halfway through the paragraph, based on my experience of attending best fires, I haven't attended large-scale best fires. I have attended fires involving homemade energy storage systems from modules from electric vehicle batteries, but that should really state attending lithium-ion battery fires.
I'm grateful, Mr. Reynolds. Can we start then just on your experience? And can I ask you to say a little bit more about the specific experience you have and how that's informed the evidence that you're giving to the inquiry?
So I have spent all of my career working with hazardous chemicals, mainly through the hazardous waste industry. So that is where my 35 years of experience comes from. So that was about classification, transport, etc., and also managing the risks presented by those, whether we be repackaging them, transporting them, treating them as a waste. From 2011 onwards, I got involved in the battery recycling industry. So it's from 2011 onwards when I started, my day-to-day job was involved in battery recycling, including lithium-ion batteries. And that is where my experience started of lithium-ion batteries. In 2011, I also became scientific advisor, working for West Midlands Fire Service and subcontracted to the 4 surrounding fire and rescue services. And that is not just a role which involves dealing with batteries, that is a role helping HMEPOs, who we have mentioned earlier, deal with what I would describe as when chemicals go bad. So that may be because of a road traffic accident of chemicals in transit, it may be because of an industrial accident and a spillage or an inadvertent mixture. It may be to do with people operating illegal drugs factories and being busted by the police and what you do with the aftermath of that, or their facility explodes unexpectedly, or it may even be the results of acts of terrorism. So that has been going on since 2011. What has happened because of my day job and because of my role as a scientific advisor with West Mids Fire Service, then I've also found myself over the last 3 to 4 years supporting West Mids Fire Service developing their own procedures as a fire and rescue service, as what they do with this, with incidents involving the emerging technology of lithium-ion batteries, whether that be in a domestic setting, whether that may be something to do with the BESS, whether that's electric vehicle fires or road traffic collisions involving electric vehicles. So that is how I find myself sitting here today talking about the hazards associated with lithium-ion batteries.
Thank you. And just to clarify, you mentioned there HMEPO, that is a Hazardous Materials Environmental Protection Officer. Is that right?
Sorry for using acronyms. The same acronym is used in the Carnegie Road report, I think. So, but it does use it in full first.
Thank you. And then very briefly, can I just ask you to explain how the evidence that you give relates to that we heard from Mr. Blunden, and where the point of demarcation lies?
Yes, certainly. So I am not a firefighter. I am not a fire officer. But I provide advice to operational, normally fire officers, sometimes firefighters. And so someone like Mr. Blunden would be the operational officer required to make decisions, and I would be acting as an advisor to support him on what to do in the early stages of the incident, what to do to try and bring it to a successful, speedy conclusion, and also regarding the handover and things to take into account when handing over a site after any particular incident involving chemicals.
Thank you, Mr. Reynolds. So I'm going to take your evidence in the order that it's set out in your proof. And the first subheading is around risk of fire and propagation. Mr. Blunden gave detailed evidence on the large-scale fire tests. So can you just explain, to the extent that it relates to your evidence, what conclusions you take from those tests?
So I conclude, having seen the design of these containers, which involve units with 10 centimetre 4-hour fire rated gaps between them, as a low risk of a fire occurring in them, or certainly if a fire did occur in them. Well, there's other contributing factors which will lower that risk, which Mr. Blunden went into in great detail. But I am also quite happy that the large-scale fire tests show that there, even if a unit was fully involved in fire, that it would not be propagating to the adjacent units.
And in relation specifically to risk of contamination, which is what you're assessing in your evidence, what conclusions do you draw?
So one of my roles as a scientific advisor, I often find myself as somebody who, would I describe myself as a pragmatic chemist? So I often find myself dealing with chemical matters and trying to convert them and portray them in simpler language. I try and demystify, when we're dealing with chemicals, the hazardous materials officers that we talked about earlier, they have somewhere between 3 and 6 weeks training on chemicals and then go away and are seen as the chemical expert, which they are not. They have some understanding of what to do in chemical incidents, but the scientific advisors offer support to them. And as I say, I see myself in that role, trying to demystify the world of chemistry. And as we've seen over the last couple of days, like, it is very easy to go down a rabbit hole regarding chemistry and maths. So part of my role is to do that. And I see myself as doing that as part of this evidence. So part of what I'm talking about is the potential for contamination. My colleagues, Mr. Rigby, Mr. Lester, and others will talk about what may happen to that contamination. So I am focusing on what may arise from a fire at a BESS involving lithium-ion batteries. But I'll leave it at that.
Thank you. And so then specifically on that, what do you say you can take from the large-scale fire tests to inform that evidence?
Sorry, the point I meant to add to the thing I said previously was what I would like to do as well, and what I try and do through some of my evidence is to put those chemicals into context. There is a lot of emotive language around the discussion of lithium-ion batteries and incidents involving lithium-ion batteries. And I'm certainly in agreement with Professor Ramsden about some of the chemicals that exist within lithium-ion batteries. What I would like to do, and again, what I do as part of my role as a scientific advisor, is put those chemicals into a context to show that, or to compare them with something, or to show that they are similar to something else. So that I think that context is important, so that it is not like we are bringing totally new chemicals to this area if this BESS is approved and installed. So I use examples of other incidents which could create similar chemicals.
If I just pause you there, because we'll come on to that in your evidence. So if we move then to emergency response planning, which is the next subheading in your proof. And again, the substance has to a degree been dealt with by others, but could I ask you to just summarize what you take from the emergency response planning insofar as it relates to risk of contamination?
So I think regarding emergency response planning, it is good to see the levels of protection which are in place for this proposed installation. One of those includes the addressable fire alarm system, and also confirmation of the fact that boundary cooling would be a strategy for dealing with an incident at the site, as opposed to trying to suppress a fire and creating slightly more contaminated fire water.
And so you mentioned there the addressable fire alarm system. Can you just explain how that would operate on the site?
Yes, so I think also this is something that is referred to in the latest NFCC guidance as well. So the addressable fire alarm system means that every individual unit has got its own gas monitors, its own temperature sensors and humidity sensors, I believe. And they are all, by addressable, what we mean is that if you're looking at the control panel, if you have unit numbers 1 to 10, you would be able to see those conditions from those monitors within each unit. So that is very useful when you're trying to, when you're having a conversation about boundary cooling. So again, boundary cooling has been discussed a great deal over the last 24 hours. But if you are boundary cooling, then an addressable system would mean that you could look at the system and you could see the temperature within adjacent containers to where an incident was occurring, and that could inform the fire officer's decision as to whether they needed to apply boundary cooling water or not. So that creates very efficient use of water, not taking away from the discussions that have just got on about recirculation, etc. So the benefit is you would use water when you needed to. And again, because we've talked a lot about system failures over the last couple of days, there are other ways of doing it, but an addressable fire alarm system is the gold standard, and it is being proposed in this installation.
And did the, or to what extent was the fire service aware of these proposals in its engagement with the appellant during the course of the application process and its comments on that?
I believe in my evidence it refers to the fact that they were pleased to see that was being proposed by the appellant.
And just for, Madam, your notes, the reference at 3.9 to CD 2.1, I struggled to find it there. I think it's actually Appendix 2 in CD 1.36, which is the document that we looked at earlier. Thank you, Mr. Reynolds. So if we can move on then to the likelihood of fire water contamination. And can I first ask you to just explain the distinction that you draw between boundary cooling water and direct fire suppression water?
Yes, so again, that has been discussed quite extensively over the last 24 hours. And if you have an incident in a BESS unit involving lithium-ion batteries in thermal runaway and on fire, then there are a couple of things you can do. So you can let it burn out, which is referred to as a controlled burn. You let it burn out. The beauty of this proposal is that that limits the amount of batteries that would be involved in that controlled burn, as opposed to somewhere like Carnegie Road, where the whole container of batteries went. So it limits the amount of, while you are boundary cooling, there's a great deal of discussion in the NFCC guidance and the strategy of boundary cooling. So boundary cooling is cooling adjacent containers. Now again, that is discussed, but that's because, and in my view, it's not required particularly. It's in place, but we have shown through the large-scale fire tests in this case that the fire is not propagating to adjacent containers anyway without any boundary cooling, but it is there in case it is required. The alternative you have is to try and extinguish the fire. It is well acknowledged that it is difficult to extinguish lithium-ion battery fires, although again, some lithium-ion battery fires are easier to extinguish than others, and I've been to several which have been extinguished by the use of water being sprayed on them. But that's all about access, how they're packaged, etc. And certainly in the situation of a BESS, I would support the strategy of a controlled burn with boundary cooling. So that doesn't mean to say that you you don't spray water directly onto the fire, which again has been discussed previously, is what happened at Carnegie Road for various reasons.
And it's perhaps an obvious point, but what is the difference in terms of the likelihood of contamination between the two types of approach?
Sorry, I was doing so well. The beauty of boundary cooling water is that you are spraying water onto adjacent containers. And as I say, I add to that, if you actually need it, but if you do need it and you are spraying it, then the likelihood of it becoming contaminated is very small. If you spray water directly onto a battery fire, then you have the potential to contaminate that with the chemicals, with the hazardous chemicals that we all agree are present within lithium-ion batteries. Although, in my evidence, as I'm sure we'll come to, we've even found where that has happened, there's been limited amounts of contamination. But from a risk point of view, boundary cooling water will stay a lot more uncontaminated. It's I thought of an analogy which was, if you had a detached house on fire, then even if you couldn't do anything about that house being on fire, then you may cool the houses next door to stop that fire spreading by heat transfer and setting fire to the neighbours. So you might lose the house in the middle, but you will protect the neighbours' houses by cooling the walls and the roof.
And based on your understanding of the proposed firefighting strategy, what would you expect to see more of in the event of a fire on the site?
I would only expect to see boundary cooling water. Given the latest NFCC strategy, that supports boundary cooling and not using direct fire suppression. That doesn't mean to say that officers retain that option if they thought it was necessary, but I think that would be very unlikely.
Thank you. If I could just take you briefly to Professor Ramsden's rebuttal proof of evidence, which is CD 15.2, and take you to page 9, which is the PDF. I don't think there are internal pages. Paragraph 3.1.
Please.
It's CD 15.2, and it's paragraph 3.1, which is within that. It's Professor Ramsden's rebuttal proof of evidence.
Paragraph number, sorry.
3.1. So there's a heading, rebuttal of the appellant's battery contaminants proof of evidence. You got that? Thank you. So at 3.1, Professor Ramsden comments on the distinction that you draw between the two, and then effectively says that you've neglected to take account of a rainfall scenario. Can I just ask for your comments on what Professor Ramsden says there, please?
So we've seen the design of the container. The container is waterproof, but has a hole in the top. If the deflagration panel is open, that will create an intense fire. And again, there's been various discussions about how hot that gets during that fire. That means that there is a great deal of hot gas moving upwards out of the top of that container. So rain falling down on top of that hot gas is not really going to get past that hot gas trying to go in the opposite direction. It will evaporate before it gets there. And the fire service, try not to talk about tactical firefighting, but if a house is on fire and it's heavy rain, the fire service don't suddenly say, well, we won't send anybody out because the rain's going to put it out, because the rain doesn't get on it. The quantities that are used in firefighting are more than what that rainfall could do. The other point I'd add is that even if you accept that some may get past that hot gas travelling in the opposite direction, it would fall into a sealed container. So the sealed container would contain any rain if it were to get into the container.
Thank you very much. If we could then turn to evidence of contamination from other BESS fires, and this starts at paragraph 3.15 of your proof. Can I ask you first to just set out the evidence that there is on contamination from Carnegie Road and what you say about that?
Yes, so the report that was written on the Carnegie Road incident, the Hazardous Materials Environmental Protection Officer, who was on site at the time, had some thoughts about whether there would be contamination of the firewater. That was firewater that was actually being placed on top of the burning batteries, as we discussed yesterday. That's because they thought they were going to a refrigerated lorry fire and started putting water on it. So it says in that report that there was some, it was only field testing, so they were doing what they could, and they were field testing, but what those field tests show, so they were measuring the pH, and the pH shows whether the fire water is acid or alkaline. That showed, or neutral, and it showed that it was neutral. So the water that was being used to start with would have been neutral, and it was still neutral after it had been used. I'm using that example there, and they haven't published the exact figures, and you wouldn't get exact figures anyway, because it was a field test, probably using pH test papers, which are very useful in that kind of incident. But I think, again, going back to the point about putting things into context, is that we acknowledge that acidic substances, which we'll come on to, can be produced during that thermal runaway and fire. But I think it just helps the context that this wasn't a river of acid flowing down the street, dissolving everything it came into contact with and dissolving the tarmac and the concrete. It was still the same pH. It was still neutral as per the water from the hydrants that were being sprayed on it to start with.
Thank you. And again, just for, Madam, your notes, the report being referred to is CD 9.5, which is the EPRI Lessons Learned report on Carnegie Road. Could I ask them, Mr. Reynolds, the same question in relation to the Tilbury fire, and again, what evidence there is and what conclusions you draw from that?
Yes, so I have seen analysis from from water samples taken after the Tilbury incident. Some of those samples were of attenuated firewater, and some of them were of existing waters which were treated as control samples. I've reviewed that analysis, and there is very limited contamination, lower than what I would expect. I can't talk about that analysis because it's confidential, but I have reviewed that, and my professional opinion is that I'm pleased to see how uncontaminated that water is, and that was even with recirculation as well, as we discussed earlier.
Can I ask if there are any documents within the core document library that do set out the findings from the Tilbury fire?
So I believe the only reference that we have, which is in the public domain, is core document 9.6, the Carrington Best Verification and Compliance Report. And at page 21, there is a comment there that was allowed to be used by the owner or the operator of the BESS facility in Tilbury. So there is a core document with a statement in it, but it still doesn't go into the analytical detail because the operator will not allow that to be released.
Thank you. And if we could go back briefly to Professor Ramsden's rebuttal, and this time to paragraph 3.2. In that paragraph, he takes issue with this on the basis that the results from the attenuated water are consistent with control samples. And he says washdown of plume contents would, of course, contaminate both attenuated water and the water course. Can I just ask for your comments on that, please?
Yes, so I wasn't allowed to go into too much detail about those samples. What I will share is that there were samples taken from attenuated firewater on site, and the control samples were taken from culverts which contained moving water. I think the incident happened in February, and those samples were taken in the summer. I think there was around June. So that comparison, that statement by Professor Ramsden isn't true, on the basis that, and even if they had have both got contaminated by the plume falling down on them, there was still nothing in them to be concerned about anyway. But what I can say is the control samples were taken from flowing water in a culvert, so even if the plume had dropped on that control sample, 3 months later, that contamination would have washed away.
Thank you, Mr. Reynolds. The next heading is assessment of how the risk of firewater contamination is mitigated in the proposed development. You've touched already on the fully addressable fire alarm system. Is there anything else that you wanted to pick out in respect of mitigation?
I think it's very good to see that when we talk about Carnegie Road, and Carnegie Road as one container filled with racks of lithium-ion batteries and the associated problems that brings with it, it is good to see now that the design being proposed here is 3 smaller units which are connected together with a 10-centimetre air gap and fire-resistant walls either side of that air gap. So it is good to see how the solutions have developed regarding that risk of fire and the propagation of fire.
And you touch in your evidence on the drainage strategy, and of course Mr. Rigby will give evidence for the appellant on that. But so far as it relates to your evidence on risk of contamination, can I just ask for your comments on that?
Yes, so other representatives, I'm sure, will discuss that at great length, but my headline opinion of that is that there are levels of containment in place to deal with boundary cooling water, should it be required. So there is provision of water on site, there is boundary cooling water, there is the ability to recirculate that water, and the boundary water shouldn't be that contaminated anyway. We should be able to limit the amount of it that we use. And then, even though it's not contaminated, when it falls to the ground, it's falling onto a liner sitting underneath the gravel, so it will be contained.
Thank you, Mr. Reynolds. If we move then to the risk presented by toxic gas release, which is your section 4. And perhaps you could just explain how your evidence in this regard relates to that of Mr. Lester, who gave evidence on the plume impact study.
So what I would like, what I would like to put into context is that I accept that there are chemicals within the lithium-ion batteries, that when those batteries are involved in a fire, because those batteries contain chemicals containing fluoride, that fluoride will be converted to hydrofluoric acid. On that, myself and Professor Ramsden agree. I think he called it total mineralization when you do that conversion. I would call it incineration or thermal destruction, but we're saying the same thing. So there are chemicals. There are other chemicals as well, but I just wanted to use hydrofluoric acid as an example, partly because it is recognized that it is a toxic and corrosive chemical, but also to try and put that into some kind of context regarding other incidents which may produce hydrofluoric acid as well. So it's to try and highlight the fact that bringing a BESS to this area isn't like it's bringing a chemical to this area that has never been here before or couldn't be produced in an incident this afternoon or this evening.
So before we get to your other examples, just to talk about the figures that you've used, you would have heard Professor Ramsden's evidence yesterday, and he questioned the figures at your paragraph 4.5 of the amount of fluorine that would be in a battery, and how that then related to your figures in table 1. Can I just ask you to explain how those two relate to one another, and any comments that you have on what Professor Ramsden said on this?
Yes, so in paragraph 4.8 of my evidence, I give a range there of that research has shown that between 20 and 200 milligrams per watt hour of HF can be released during thermal runaway of that battery cell. I didn't give a reference for that, but it actually came from Larson et al. But what I can point out, so again, I needed to choose a range to come up with a calculation to try and just put something into context. There is another control document which is 8.2, sorry, a core document which is 8.2, which is used, I believe, by another representative of the appellant, which is the Larson et al. Document. And again, that uses a range of 39 to 81. But if we use the figures that I used in my calculation and that Professor Ramsden was critical of, so what he was saying was that if you've got anywhere between 0.3 and 1.5%, then if you converted all of that material, if you converted all of that fluoride to hydrogen fluoride, then that would give you anywhere between 30 kilos and 150 kilos. And I'd used 13 as my calculated figure. The way that I would explain that is that, so first of all, it is a range. So the range is 30 kilograms to 150 kilograms. And what I did was put a correction factor in that, in the weight of HF produced. And the reason I did that was because where those ranges are coming from research in laboratories, what they are doing is taking one small battery cell and they are fully igniting it under laboratory conditions and seeing how much hydrofluoric acid is emitted, and then you can do a conversion and say, well, how much hydrofluoric acid did I get per watt hour of power in the battery? I reduced that because to get 13 from 30, because you, in reality, in a BESS, you are not going to get 100% destruction. You're not going to get 100% involved in fire of the batteries in that unit. I think the tests that were done on the propagation tests show some of that as well. But again, trying to use something as an example, which is a good analogy. If I take some a few small twigs and I have a campfire and I burn a few small twigs, and at the end of the night, I'm not going to extinguish the fire and I just go to bed. When I wake up in the morning, those few twigs will have totally burnt out, or most of them will. If I have a fire with some larger logs on it, perhaps logs which are 2 or 3 inches thick, and I have a campfire and I go to bed and I think, well, I'll just leave it to burn out. You can bet in the morning when you wake up, you will still be left with parts of those logs. The end bit sticking out the side of the fire will still be there. So I was using that analogy with, there may be an amount of total fluoride present, but all of it can't be or wouldn't be converted into hydrogen fluoride. To some extent, the figure I was using was only to kind of put hydrofluoric acid production into context with other incidents anyway. So I could have used 30, I could have used 150, and another representative on behalf of the appellant will be going into that in much more detail and their own accurate modelling of HF production and what happens to that HF.
So you then take that figure, as you say, and you put it into context. And what conclusions do you draw when you put it into that context?
So this is part of putting thermal runaway and fire in a BESS involving lithium-ion batteries in the context of other incidents that may happen in this local area this afternoon or this evening. So the example that I used was that if an auto workshop is offering aircon recharging services, then generally they have an 18.5 kilo cylinder of that air conditioning gas, which contains a lot of fluoride, in their workshop. If that workshop catches fire, and as we've said, like many buildings catch fire, according to Mr. Blunden, there's more fire in other buildings than there is in BESS facilities, and certainly many workshops do catch fire, then that could fully involve that cylinder of gas containing fluoride, and I think the example shows that it produces about 13.5 kilograms of hydrogen fluoride. So even if you disagree with my figure of 13 and it's like, well, use the upper range, it was really to make that comparison. So I stayed in the Premier Inn last night. 10 meters away from where I was sleeping last night is an auto garage. That auto garage on their website is advertising that if you have your MOT done in March, they will do a free aircon recharge for you, which means that they've probably got one of those 18.5 kilogram cylinders of aircon gas, which contains a lot of fluoride, in their workshop. But I wasn't lying awake in bed last night waiting to be like consumed by a cloud of hydrofluoric acid gas.
So just to draw that to a conclusion, then, what do you say is the relevance of that when thinking about the risk of gas release from a BESS fire?
I think it's just to put it in some context there, and that is just one example. There are many other sources of fluoride in fires in non-lithium-ion battery incidents. So it's just to put that in the context that although there's been a lot of discussion about hydrofluoric acid and its production from a fire, that there are other incidents currently which could create similar amounts of gas. And even if you used a figure double my 13, or you doubled it to, or you went to 50 kilos, then I could argue, well, what if you've got a workshop with 2 cylinders of this similar gas? So it was just to try and put it in some kind of context that the production of hydrofluoric acid during a fire is certainly not just limited to BESS facilities containing lithium-ion batteries.
Thank you. Moving then to PFAS, which has been mentioned a couple of times. Can I ask first, just in general, what contains PFAS? Where do we find it?
So PFAS refers to, I think, about 5,000 different chemicals. Those chemicals have all kinds of uses. So the Teflon coating on your frying pan is PFAS. Teflon is PTFE. PTFE is PFAS. If you have a waterproof Gore-Tex coat, Gore-Tex is PTFE, which is PFAS. They are in many different places. They are in textiles, they are in lubricants, they are in cosmetics, they are in all kinds of places. And they've been around for a while, and because they've been around for a while, and because they are also known, and I agree, they are also known as forever chemicals because they are quite persistent. Because of their chemical structure, it makes them quite resistant to being broke down in the environment. So if they don't get broken down, then they hang around, they accumulate, and that is why they are with us and why we are discussing them a great deal. But I think again, it's to try and put this in context that, and hopefully that introduction helps that, is that bringing lithium-ion batteries to this area is not bringing a new risk of PFAS. Anyone with a frying pan and using a metal implement on it, which you're told not to, is probably scratching the surface and ingesting PFAS themselves, as well as all the other uses.
Thank you. And thinking specifically about PFAS and drinking water then, what guidance or standards exist to limit that, and what are those standards?
So, and I think this was discussed in the previous witnesses' evidence, that PFAS is in the environment. It is getting into controlled water, including drinking water supplies, and the map that is shown in paragraph 5.7 is from the Forever Pollution Project, and it's just to show that PFAS is already present in this local environment. I think the example there, the writing might be a bit small, but that I believe is a sample taken at the Merriott Sewage Treatment Works, which I think is about 15 miles away from Axminster.
And that's, you're referring there to figure 3 under your paragraph 5.7, are you?
Yes, that's right.
Again, thinking about the risk in relation to a best fire, what do you say the relevance of this is?
So the relevance is that PFAS has been discussed a lot regarding lithium-ion batteries in a BESS, and again, we agree that they are there, and we can discuss how much we think is there, as that was discussed yesterday as well. So we can discuss how much is there, but we accept that there are some there, but it is to put this into the context that this is not a new risk which is being introduced to the area. I'm not suggesting that because it's there, it's okay to add to it, and that's not the case, because there are many levels of safety which will be discussed at length which would prevent that. But it's almost like if they did get released, it's not like this is a chemical which isn't already in this area. It would not be a new chemical contaminating the environment in this area or any other area of the UK.
Thank you, Mr. Reynolds. So that's the general picture. If we could think specifically about the site now, and if I could take you again to Professor Ramsden's rebuttal proof of evidence and to paragraph 3.5 on page 9. And Professor Ramsden there says that there would be about 200 kilograms of PFAS in the unit. And I think he accepted, when he gave his evidence, that that was effectively a calculation based on 2% of the 10 tons of the total weight of the unit. Can I just ask you to comment on that calculation and the figure that he arrives at of 200 kilograms of PFAS?
Yes, so as we discussed yesterday, Professor Ramsden made the incorrect assumption. He knew there was PFAS. He knew there was the potential use of PTFE in the separator. He made the assumption, and he did a calculation which says the separators weigh 200 grams. Unfortunately, he made the assumption that the separators were made of PTFE. The separators are actually made of plastic. I think Mr. Blunden described it as polyolefin. They are trying to use simpler language. They are plastic. They are made from polyethylene, which is the same as the milk bottle in your fridge. But it does have PFAS, which I'm not disputing. It does have PFAS. It does have PTFE as an additive in that polyethylene to give it the required properties. The thing about PTFE and many other PFAS is that they have certain properties that are found very useful in many different applications, whether that be grease resistance, wetting capability, etc., water resistance. So they are there as an additive. So what I would say is that 200 grams would be much smaller. Sorry, 200 kilos.
I was just going to pick you up on that correction, because I think you said that before as well. So Professor Ramsden says 200 kilograms, and you say it would be smaller. Is that?
Yes, that's right. It would be a small percentage of that. If you use the example of a frying pan, if a frying pan weighs, I don't know, a kilo, you wouldn't say it was a kilo of PFAS. It's got a very thin coating of Teflon on it, but the percentage of Teflon in a frying pan is probably less than 0.01%.
And I don't think it was in his written evidence, but in oral evidence, Professor Ramsden also referred to the binder and suggested there would be PFAS in that. And can I just have your comments on that?
Yes, so again, I would agree with Professor Ramsden that the binder also contains PFAS. The binder is, for want of a better term, is the glue which is used to stick the active materials onto the metal foils. So again, even that it is there as a low percentage additive. I mean, it's a glue, so apart from gluing things onto the electrode, manufacturers want to use as much of the active chemicals on those electrodes. The glue's not doing anything apart from sticking the chemicals onto the metal foils. So it is, again, a small percentage of the overall weight, but I accept that it is there. PVDF, which is the chemical referred to in the binder, is used, and that is PFAS. And it contains fluoride.
Thank you. And then thinking specifically about a BESS fire, what, in your professional opinion, would happen to PFAS in such an event?
So I think we've talked about the hot temperatures, and I think Professor Ramsden agreed of the hot temperatures being reached during a fire. So although that may be in other fires that may be a disadvantage, the beauty of a hot fire is that it will destroy. There will be in a plentiful supply of oxygen that will destroy the PFAS. It will burn them. I think Professor Ramsden referred to it as total mineralization. I would refer to it as combusted, incinerated, thermally destroyed. But they would burn. That hot temperature and the presence of oxygen will mean they are destroyed, and they get converted to hydrofluoric acid, which is why we have a conversation about the production of hydrofluoric acid.
And just to finish that then, what in your opinion would be the likely quantity of PFAS released in the event of a BESS fire?
So it would be minimal. We are talking about, so first of all, the quantities we are talking about, now we've accepted that the 200 kilos of the binder was orders of magnitude out of the actual figure. We accept PVDF is there as a binder, but again, the percentage is very low in the electrodes. So the starting quantity of PFAS is a small percentage, and the hot temperatures and the presence of oxygen allows it to be destroyed.
Thank you, Mr. Reynolds. Final couple of questions. At section 6 of your proof of evidence, you refer to applicable legislation. Can I ask you first at what point this would be applicable?
So the reason for including this is to just try and set the scene that if a fire occurs and boundary cooling water is applied, and that boundary cooling water were to be contaminated and then contained within the containment system on the site, that this is just to highlight there is a legislative framework in place to control what happens to that water. It's not like somebody can just turn up, open the tap and think, oh, that's okay, we'll just drop it now. And I saw further information earlier about the attenuation pond and the penstock valve. So it's like, it's to set the scene that there is a framework to control what happens to that. Well, we're calling it fire water. I would prefer to call it boundary cooling water. So that there is a framework in place, and it's not just a case of, well, we'll spray it on the field adjacent to the site or whatever. There is a framework in place to make sure that that material is handled in a way that reduces harm to people and the environment.
And are there any you wanted to pick out specifically? You've listed them there in your proof of evidence.
Yes, so just to give an example, so the hazardous waste regulations of 2005, they are a certain set of regulations which are in place to control the collection, movement and disposal of the most hazardous wastes. So if there was enough fluoride in there to make that water hazardous, which is very unlikely, so the threshold to make that hazardous waste as a fluoride would be 0.1%, which we are seeing nothing getting near 0.1% fluoride in that boundary cooling water. And just on that point, putting things in context again about the toxicity of things, it is accepted that fluoride is toxic to humans, but at home I've got some high fluoride toothpaste, which is 5,000 ppm. So that is 5 times higher than the threshold of the amount of fluoride that would make that boundary cooling water a hazardous waste. So that's just to give an example of that. And then there's also, I think the Water Resources Act, which again, I think got mentioned earlier about controlled waters and discharges to controlled waters. You just can't tanker that material away and decide to put it into a controlled water course. It was discussed earlier that there are controls in place to prevent hazardous polluting chemicals being discharged into controlled waters.
And final question then, you've said that this legislation would apply in the event that a fire had occurred and there had been boundary water cooling and that had still led to some contamination. What do you say is the relevance of this framework of legislation in regard to the risk to local people?
So this framework of legislation will mean that, regarding all the ifs that I used earlier to kind of get to the point where you end up with some contaminated water, that it will be handled correctly so that it does not present harm to the environment or to people.
Thank you, Mr. Reynolds. I don't have any further questions.
Okay, Mr. Parkinson, have you got an idea about how long you're going to have cross-examination?
Yes, more than 10, 15 minutes. I think, probably, well, at least an hour. If the question is whether we start now or start tomorrow, I don't mind, but I think doing 10 minutes now is probably not that great a use of time. Maybe we could use the time now to go through the core documents and get those all ready. I'm quite confident, though, that we could do Mr. Reynolds. I don't know how long Mr. Rigby in chief will be, but assuming sort of 1 hour, and cross-examine Mr. Rigby, who I think isn't dealing with all the infiltration stuff. That's really for Mr. Fellows. Yeah, so I'm confident. Well, I say confident. I think we could do all of that in the morning.
Okay, on that basis.
Well, hang on. Yeah, I think there's a chance we could do it all in the morning.
Okay, I'm not seeing a great deal of dissent from that on the appellant's side, so let's aim for that. It will be helpful, though, Mr. Parkinson, to have the list of the core documents so that we can be ready to go.
Shall I do that now?
Yes, please.
Yeah. So it is CD 9.2. CD 8.18, which is the DSFRS response. CD 1.35. CD 9.6. CD 9.7. CD 12.12. The NFCC guidance, which I've got as Appendix 9 to Mr. Elliott's proof. Yeah.
Also 5.24.
5.
Sorry. For document 5.24, if you've got PDFs, it's the NFCC guidance.
And CD 4.1.1.
Okay, have you got a note of those, Mr. Reynolds?
Yes, I have. Thank you.
Jolly good. And whilst you're getting your documents ready, if you could just have a look and tell me in the morning, paragraph 6.10 of your proof. I just can't quite make sense of the sentence. So if you just have a look at that overnight and tell me, that would be helpful. Thank you. Okay, so we'll leave Mr. Reynolds there for now. Mr. Reynolds, you understand the position that you're in overnight, do you? Billy no mates?
Yes, I do. Thank you, madam.
Okay, thank you very much. And so now if we could just deal with a few housekeeping matters. I'll just turn to the council. Bats?
My main involvement of the day is to hand up a statement on bats, which is agreed. Happy report. So that's, I think, have you got a copy of this already or not? Yeah. So that's agreed between the local planning authority and the appellant. The other note on birds, I think, is being discussed between the planners, and so hopefully we'll get that to you before the end of tomorrow.
Okay, and has the Rule 6 party seen the note on bats? Can you just pass it over to Mr. Parkinson so he knows what's just been handed up to me? just tell me tomorrow morning if there's any issue with it. Thank you very much for that.
Madam, on the core documents, I understand, or not the core documents, the inquiry documents. I think Mr. Gary, he was saying that there were a couple of interested party written submissions from day one, which we received yesterday. And so I think we're up to about ID 11 on the website. And so that, if you allow it in, will be ID 12. I think.
I had noticed that a number of the documents are coming through to the case officer as well, so thank you for doing that. I also noticed that there is, from the Rules 6 party, I think, a draft proposal for a site visit itinerary. Marvellous, thank you very much. Mr. Parkinson was totally on top of that one. It's in written form, and I'm just going to nick that little phrase I always use, words fail, see sketch. Can I have a picture of it for me?
If it helps, madam, we're taking care of that. We've got the locations now. Yes, we received them, so we're compiling a plan together with our own suggestions, and just to make sure you've got full coverage of everything that everyone wants you to see.
Okay, marvellous. I did think it was a bit of a test for me. Right, okay, so we've got that. Are there any other housekeeping matters that we need to deal with? Okay, and timetable. Are we going to look at that tomorrow after lunchtime, see where we've got to then? Does that make sense? Yeah, we're happy with that.
Sorry, forgive me. What time were you thinking about your site visit for Monday? When would that commence?
Well, I've been thinking about that, and there is a certain amount of flexibility with it. So I'm flexible both for the participants, but I would like it to start early enough in the day that if the weather forecast does go bad, that there is the opportunity for me to say, well, you know, I'm going to come back a bit later and do this, because the forecast seems to be changing for Monday. Sorry, does that help you at all? What are you
yes,
thinking?
it does. We're just trying to plan who's going to come and when. So that is useful. Thank you.
Have you got particular times that work for you? I was thinking of not starting before 11, for example.
I think that would work fine. Yeah, I'll confirm, but I don't see that being a problem.
Okay, just thinking about other people who are being coordinated, does that raise any concerns? Thank you very much for that. Conditions, I don't want to let you all down. We did feel as though we made a good start with them, didn't we? From the evidence that I've been hearing, there is quite a lot of work to be done, isn't there, to try to make it a lot more specific and tailored in relation to the evidence. I am looking slightly to the appellant side to, with a wishful look, for you to take the lead on this too. I think there could be some quite big redrafting in some areas.
Yes, we'll do our best to be the genie and grant your wishes on that. We have started working on them, and we've already made some additions. To give an example, to deal with the replacement of batteries at around the 15-year mark, that sort of thing. All of that needs to be put in and appropriately managed. Monitoring systems, all those sorts of things. So we've been listening carefully and thinking about how we might, and it's unfortunate to say expand, but I think make more robust the list that's currently there to reflect what you've been hearing and what needs to be secured. So we're on it. As soon as we we'll probably try and get out a list, I would have thought, by tomorrow to the other parties so that everyone can have a look at those before we resume on Tuesday. But as I said earlier to Mr. Carpenter, I really would invite any observations the Rule 6 party has, of course without prejudice, but in the event that planning permission is granted, what would they really want to see?
That would be really helpful if there could be a bit of joint working between experts in this area, because I do feel I've got some quite generic conditions in front of me at the moment, and I'm not sure that they're working.
Madam, perhaps, given that we're all, as a team, gathered here this evening, we can have a conversation, and then maybe tomorrow Mr. Jones can speak to Mr. Bradshaw and have a discussion, and we can feed in our points that way.
Okay, thank you very much for that. Is there anything else that we need to attend to today?
Just one point from me. The council, I think, has they have rooms booked for Monday, but my understanding is we're not planning on sitting on Monday apart from the site visit, and so it's fine for the council to release the rooms. Is that okay?
Absolutely, yes.
Thanks.
Okay, on that note, we shall adjourn until 10 o'clock in the morning, when we shall start directly again, and we'll go to cross-examination with Mr. Reynolds. So thank you all very much for your help today, and see you in the morning. Thank you. We are adjourned.